Hello, everyone. My name is Amanda Byer, and the title of my presentation is Placing Property, Landscape, Spatial Justice, and the Common Law. This is based on a first paper which explores the uptake of property in the common law as part of my research within the Property and Justice Project at University College Dublin. Property and Justice investigates the concept, definition, and interpretation of property rights in international law as they relate to land, paying special attention to the way in which international law facilitates spatial injustice and injustice through its acknowledgement or dismissal of geographical disparities. In so doing, the project will address whether property is broad enough to include socially embedded notions of land and advocate for a more socially just interpretation of property. Previous genealogies of property have traced the concept through time, but this is a legal geography of property, which looks at where, not just when, property developed. The geographical origins of legal concepts and their impact on specific places are relevant to the crystallization of the law. Legal geography treats law's presumed neutrality as spatial blindness and asks how established legal categories can be reconciled with the reality of geography. This requires integrating the material conditions of specific places into the law. Legal geography is also cognizant of the historical context, examining material conditions, limits, and connections over time. Attunement to place means that laws are geographically sensitive, reflecting the local context, or simply put, justice as a geography. So first I consider how property evolved in England through earliest land use, and then I examine the hallmarks of property, individuality, exclusivity, and alienability through the eyes of leading property theorists, Locke, Blackstone, and Marx, situating their scholarship in the specific geographic locations that influence their ideas. Property originally invoked an integrated relationship between people and place, a relationship that linked land with identity. This is derived from the Old French property, from the Latin proprietas, meaning proper to one's own or special character. The French word proper means clean or suitable in the sense of close or near or in place. And real property signified a human relationship with the physical features of the land that overrode lesser forms of property, goods and animals. Real property could not be defined without this identifying set of geophysical and cultural relations. Land's location settled land claims, not who owned it, but where. Nevertheless, today it is the secondary meaning of property that prevails, meaning an interest in having a thing rather than the attribute or characteristic of person or thing. The idea of land as a base of place-based identity or landscape predated conceptualizations of property and contextualized the relations, rights, and emergent institutions associated with land. Land was therefore not just a substrate, but a polity, a system of nested obligations, use rights, and institutions representing a people and its relationship with the material environs. And the etymological and archaeological evidence support this. Landship or landscape in the Old English spelling is derived from the Germanic family of languages. I won't mangle the pronunciations here, but you see them up there. And land has been managed in common since before the time of Anglo-Saxon settlers. Archaeological evidence indicates that open field systems date at least to the sub-Roman period, if not earlier. These Brittonic landscapes did not disappear with the arrival of the Anglo-Saxons, as these new inhabitants continued to manage them communally. The Anglo-Saxons came from Angeln, Frisia, and parts of Saxony. These regions were home to peasant republics, in which communities adapted to challenging environments in response to the limits of the ecosystem and defended their homes from feudal influence, a dramatic process that determined their customs, institutions, and a way of life. Not unlike our old country with its own legal system and representative council. Such land use systems were not primitive or idyllic in character. They were flexible in order to accommodate the layered and socially complex structures of their communities, where common property rights coexisted with vertical hierarchies of all kinds, whether social, religious, political, or economic. These landscapes could adapt and reinvent themselves, as was the case with the arrival of the Normans, marking the beginning of the feudal period in England, and changes to procedures and land use. Today, property is viewed as abstract entitlements exchanged between persons that are alienable from rather than proper to a person, no longer attached to or even integrated with the identity of an individual or community. Landscapes demotion is also evident by the word's re-entry in the English language in the 15th century, associated with scenic values such as landscape painting and gardening. So why this divergence between property and landscape? Why the shift? This requires an examination of property's foundations. John Locke's explanation and justification for the acquisition of property is foundational to the common law's treatment of land, but what is absent is a consideration of landscape, particularly Native American landscapes, in the development of that theory. In delineating property rights, Locke envisaged common land as waste, disregarding its original meaning as a complex outer zone of the commons. Waste was redefined as idle land, land in its uncultivated, underutilized state. It was rational man's withdrawal of land mixed with his labor as property that was distinctive, not the communities and their relationship with the land. This idea of vacant space was enabled by Locke's dismissal of native land use, so primitive in impact that nature remained virtually unspoiled in the Americas. Locke's wild Indian stereotype failed to address the reality of land use, native land use, and conceptualizations of property in pre-Columbian America. Native Americans were hunter-gatherers as well as dedicated farmers living in diverse environments across the continent. Because land was not a commodity as Locke defined it, but the bulwark of Indian identity, exchanging it for currency was antithetical to their way of life. Landholding and land interests across pre-Columbian America varied from one environmental setting to the next, subject to varying degrees of community control. Land could be owned by particular households, temples, local chiefs, or a particular class of nobles, and worked by the community. Hunter-gatherer tenure developed according to functions, such as hunting, fishing, and burying, which in turn shaped the way space was understood and defined. Various groups lay claim to overlapping areas for distinct foraging purposes, depending on the resource or the ecosystem. It was even possible for people of different nations to share hunting grounds. And this indicates that various indigenous peoples were not passive actors, but managed and manipulated their environments through a wide variety of land use arrangements, privately or communally owned, collectively managed, subject to a range of use rights. This description of native landscapes as a wilderness and waste thus played an important role in the development of Locke's theory of property, as the enclosure enabled the property as individual ownership model to flourish. Locke removed the locally distinct character of landscapes and highlights instead the distinctiveness of the rational individual in withdrawing land from the homogeneous, uncivilized wilderness, adding value through labor to create private property. This theory relies on an uncultivated nature that is open access in order to emphasize the role of the individual at the expense of landscape. So William Blackstone emphasized the exclusionary character of individual ownership. This is best captured in Blackstone's oft-quoted passage in the commentaries on the laws of England. There is nothing which so generally strikes the imagination and engages the affections of mankind as the right of property, or that sole despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe. What is relevant here is that the right to exclude means that one has property, and conversely, to the extent that one does not have exclusion rights, one does not have property. In this definition, property is so absolute as to permit no infringement, not even for the common good. Blackstone was determined to secure the common law's place as the law of the English, and contrasted what he deemed foreign oppressive Norman law with the common law's indigenous nature, based on the Saxon law and its perceived individual freedoms. Embedding this view involved recasting the lived-in values and experiences of commoners in the landscape as constraints upon the land, introduced through the Norman feudal system of tenure. This provided Blackstone with a pretext for stripping away the social dimensions of landscape by re-envisaging non-ownership interests as burdens on the land. To emphasize the imposition of these feudal incidents, Blackstone described a feudal pyramid of obligations that relies on problematic historic sources from English medieval property law. Land being subject to royal jurisdiction did not necessarily indicate subordination or less than normal free rights of property, and yet the term tenure was generally applied to all forms of medieval English property. Blackstone presented a model of property that was clear and simple, precisely because it was ahistoric and aspatial. The reality of the pre-enclosure commons in England overturns this generic feudal pyramid. The property relationship, held especially by commoners, was closer to the original sense of the word property, referring to identification with and from place, rather than ownership over it. Place specificity generated a subjective relationship that bound commoners in a mutually dependent relationship with the land. As members of a peasant economy based on open field agriculture, they shared a heritage derived from generations of occupancy, articulated and reinforced in the laws and rights of the commons. The original land laws of peasant economy were diverse rather than uniform. Customs were locally developed and relevant because they were sensitive to varying local geographic conditions. Providing highly specific limits or conditions to rights of access, use, and enjoyment of land and other local resources had been an early form of natural resource management observed over centuries. In Blackstone's time, the suppression of these customary rights of common people through the Enclosure Act was not the result of an intrinsic failure of land management methods or diminishing fertility of these lands, or even the collapse of these communities, but simply because the land could be acquired for improvement, which enriched the landed class. Enclosure occurred regardless of the location of these lands, and the law minimized the extent of common rights in order to limit compensation due to commoners. Private property was not the inevitable outcome of a linear process in which a progressive society eventually replaced an inefficient common property model. It was a deliberate policy choice that ignored extant cultural perspectives on land and eliminated institutions for managing land efficiently as the basis of community life. Blackstone was foundational to the shaping of this new legal reality. Marx observed the consequences of propertizing the landscape for displaced commoners that Blackstone and Locke did not. The idea of an unalienated relationship between people and nature underpins his philosophy of property and critique of capitalism. Rendering land as abstract and alienable property demanded the dephysicalization of the landscape, the separation of the sociocultural, the communal bonds between people and the land, from the ecological, so that nature could be reduced to natural resources or raw material. The alienation of labor under capitalism thus has as its precondition the alienation of nature, the severance of human beings from the land and from their natural environment, which enables both human and ecological capacity to be exceeded in order to maximize exploitation. This is known as the metabolic rift. In Ireland and the Irish question, Marx noted that at the beginning of the 19th century, agriculture in Ireland was characterized by extreme land subdivision and increasingly high rents, forcing traditional communities to relocate to the west of Ireland and adapt their land practices such as Rundale in order to survive in a harsher environment. During this period, the potato was introduced, and while communities initially flourished, the dependence on this crop and the monocultural practices that followed must be understood in the wider context of British mercantile colonialism, which expelled communities from their homes and set the stage for extinguishing communal bonds to land. The intensification of these practices and the limiting of options for communities exhausted the soil, making these landscapes vulnerable to the Great Famine. For Marx, the primary issue was not the plant pathogen itself, but the social conditions that had paved the way for the famine, transforming the socio-ecological subsistence base of Ireland. In impacting soil fertility, the social, economic, and political integrity of land was undermined. In monopolizing access to land, landlords dismissed the natural limits of the land. Marx thus demonstrated that property rights could have implications for the physical limits of the environment. This could not be separated from the social relations communities developed in their interaction with the environment. Monoculture and the resultant famine reflected particular understandings of land at odds with its natural limits and the communal bonds communities formed with the environment. The laissez-faire approach to the economy promoted beliefs that the famine was a natural phenomenon and its adherents advocated a policy of non-intervention in order to allow for market adjustments. The practices and policies accompanying legal transfer of land in Ireland were thus never tuned to the rhythms of the landscape. Colonial land transfers were antithetical to the traditional way of life and distorted the internal dynamic of the landscape that communities had relied upon for common survival. The displacement of peasant communities to marginal areas in the west of Ireland severed their relationship with the land. Eventually, the communal mode of production disappeared, replaced by the capitalized agrarian sector. The conditions for the rejection of traditional tenure, however, were not inevitable outcomes of the working landscape, but deliberate results of propertization meant to detach communities from the land. The homogenizing, externalizing, and dephysicalizing effects on the landscape facilitated property's retreat from grounded perspectives on land. Property is now characterized by these anti-communal, anti-social, and anti-ecological aspects. And all that is left of landscape in terms of representation is its visual rather than political sense. Landscape's sociocultural and ecological functions have been reallocated to new areas of law, planning law, environmental law, and cultural heritage law as subsets of property law, and they operate as proxies, insulating private property rights from challenge. This paper expands the critique of property, situating property's origins not in Lockean political economy, but in pre-feudal landscape. It uses the landscape's lens to trace the development of property in English land law and the common law system as it diverged from a cluster of place-derived interests to become abstract rights of ownership. And the paper attempts to recover the spatial parameters of property as explicated by Locke, Blackstone, and Marx. Property's divergence is not a result of a linear evolutionary process, nor is it responsive to natural changes in the world. Rather, it's a result of enclosure, colonization, and displacement, and its ascendancy coincides with landscape destruction. Property resists emplacement, and this has had profound consequences for land use and access, the survival of communities, and the sustainability of the environment. But the deficiency of the concept is only fully evident through a legal geographical lens. Embedding law within its geographic reality emphasizes the absence of landscapes, specifically these sustainable, location-based understandings of land that reveal land really in all its complexity. And a thorough critique of property law thus necessitates this examination of the divergence between landscape and property. Thank you.